Okay, good afternoon once again, everybody, and welcome to Thoughtful Thursday. We're going to make sure that we get everybody muted, but we want to make sure that everybody feels warm and welcomed and warm and fuzzy. So make sure you put something in the chat box to just greet your partner or your neighbor on the virtual line. But just welcome to Thoughtful Thursday, everybody. Today, we're going to be talking about rental assistance and housing laws. And we have a great guest presenter who's going to present on this topic. And I got to talk to her and get some information for her bio. And y'all, she don't sleep on her. She's really accomplished. So I'm excited to introduce Erica Singleton today. Today is January the 21st, 2021. And this is our 8th parent engagement session and Thoughtful Thursday. So thank you guys for hanging in there and for being a part of this. The Improvement Association is doing wonderful, wonderful work in the community. We're still, working on this COVID thing and this pandemic, and we're hoping to get back to normal at some point in time. But in the meantime, we want to be safe. We wish our families well and want them to have happy outcomes and successful outcomes despite the pandemic. And so today we're going to talk a little bit about rental assistance and housing law. And our guest presenter is Erica Singleton. Ms. Singleton is a comprehensive certified housing counselor and a rental specialist. She has worked with the Improvement Association for nearly 16 years and serves as the Housing Program Director and Workforce Development Program Manager. She also serves as the Vice President of the Board of Virginia's Association for Housing Council. She is a member of the Crater Area Coalition for Homelessness, and she's a proud native of Brunswick County and a proud mom of an 8-year-old daughter. And I'm excited that she's one of my friends and colleague with the Improvement Association. She always gives me good words of encouragement, and I'm happy to introduce her. So without further ado, I want to welcome Erica Singleton. And y'all can give her a virtual applause.
Good afternoon, everyone. I have not seen some of your lovely faces in such a long time. It's good to see you. I hope everyone is being safe. Thanks, Ms. Miller, for the invitation to share a little bit of information with you guys on housing today. With the current pandemic, so many things are going on. So many people are in need of assistance, and some people are actually, lost as to what to do to attempt to get housing. I know if you're employed with the Improvement Association, the first thing you're going to do is come to me, but I do want to share some information. And I want to also share some information about the laws that changed as of 2020. We have so many renters that I speak with or contact the office who don't know their rights and responsibilities as a tenant. And I think some of this information may be able to assist them going forward in the future, or even if it doesn't help anyone directly on this call today, you may be able to share the information that may help someone else. So I just believe in sharing the knowledge to all. Due to the time restraints, I'm going to kind of breeze through. You're going to see some slides that I'm going to skip across. I just want to hit some of the key points so everyone can get some of the basic needed information that's out there right now. So to begin, I want to start with right now with the crisis with the COVID-19 pandemic. We have a lot of people who are out of work, lost employment, hours were cut, stay home with the kids, don't have daycare, adequate care. With that, they're unable to pay their bills. They're unable to pay their rent and or mortgage. So back in June, the end of June, the governor came out. Virginia got $50 million for housing assistance through the CARES Act. And at that point, the Improvement Association was awarded monies to serve the community through the Virginia Rent and Mortgage Assistance Program. That was to help individuals who were behind on their rent and mortgage due to the pandemic back until April the 1st of 2020. As of November 30th, we no longer provide that assistance. We stopped taking applications. It was taken over by a call center for the state, and they handle all of that information. So if anyone is in need of assistance for rent or mortgage that's past due that was affected by the pandemic, they now have to call a number, go on a website, or the landlord can apply for them, and they still are able to get a one-time assistance with past due rent arrears back until April the 1st, 2020. They are extending or adding additional funding to this money. Now, I will let you know and be honest and transparent. This new call center, it takes a long time. People complain about us being slow. No. We were a two-man show, myself and Ms. Finer. With this new program, you have to be patient and you have to stay on them. And if you call them, you're going to be on the phone for a while. The reason why I'm sharing this information is because what I'm about to share, there are new regulations in place starting January 1st, 2021 in regards to individuals being evicted. And I want tenants to be aware of this information. And let me find the screen. Give me 1 second. My mouse decided to stop working today, so bear with me. Here we go. Okay, so as of January 1st, these are the rental protections that are in place for individuals who may have become behind on their rent due to COVID-19. So I'm going to breeze through these, and if anyone has any questions, I'm more than happy to answer them. So starting January 1st, 2021, through the end of the COVID-19 emergency, your landlord cannot evict you unless they meet the following requirements. A landlord must give you written notice letting you know how much rent you owe. The notice must give you 14 days to pay the rent owed, okay? At one point in time, you may be familiar, it was 5 days. You had to have a 5-day pay or quit notice. Now, at this point, if the landlord was to go to the court to file an unlawful detainer and take a 5-day pay or quit notice, they would not allow them to file it. They have to give you 14 days to pay your rent. On the rent notice must include information about how to apply for the Virginia Rent and Mortgage Relief Assistance Program. And that's the program I was just explaining to you. Second, if you don't do that, your landlord also has a portal with Virginia Housing, which was known as VHDA, Virginia Housing Development Authority at one point in time, but they recently changed their name to Virginia Housing. Your landlord can apply for you for RMRP within 14 days of sending you the notice. Your landlord may be able to get assistance faster than an actual tenant going through the RMRP call center. So if you know anyone experiencing that and you know a landlord and they have a tenant that's behind, because this is affecting everyone, you can let them know, hey, you can apply for your tenant. Just go to this website and click on this link and follow the instructions, okay? If rent relief is denied for one of the following reasons: you refuse to apply for RMRP and refuse to cooperate with your landlord, the RMRP application is not approved by the agency within 45 days after it was submitted, the application was denied because you're ineligible for the rent relief, or the RMRP program has run out of money. So that's for basic. For landlords who own more than 5 rental units, they also must take extra steps before they can evict you for non-payment. The landlord must offer you a payment plan without, and this is the key, without late fees. The landlord cannot evict you unless you refuse to enter into the payment plan or miss a payment. but the landlord only has to enter you into a payment plan one time per lease period. So again, that's going to be depending on the lease. Most leases are 12 months, but a lot of landlords are now, due to liabilities, are switching to month leases. So that's an advantage with this situation. You can enter a payment plan and apply for the RMRP assistance at the same time. To get on a payment plan, you must A, agree to a payment plan in writing, and B, give your landlord a signed statement that you have lost income and or had increased expenses due to COVID-19. And we do have some example statements. I'm not going to click on this one today, but it can be a basic, statement. So I just wanted to put that out there first, because I feel like that is important, because there are so many people who are suffering due to no fault of their own, due to this COVID-19 pandemic. And I just want to help them. And I'm also helping landlords, because landlords don't understand what they have to do now. They're going to go to the courts with a regular pay or quit notice and then try to apply for unlawful detainer, which is an eviction notice. And tenants try to evict their tenant, and it's not going to go through. So that's something that I did want to share with you guys, that you may be able to assist someone else. So there are still protections in place. There's still money out there with the CARES Act for individuals who are behind in their rent due to being affected by the pandemic. With that being said, what I'm going to touch on now, I have so many individuals who contact me in regards to their rights. Say for instance, if they're renting and their landlord tell them, you got to be out by Friday, but they haven't had any paperwork, or repairs need to be done and they withhold their rent money. A lot of this stuff has changed as of July 2020. Even before, people did not know their rights. But again, knowledge is power. So I'm going to share with you, again, I'm going to click through some of these slides and may skip across a few of them. If you see anything that you need, or if you want a copy of the slideshow, I do not mind sharing whatsoever. We can get an email to you. You can contact Ms. Miller. I'll get it to her and she can share it with you. Okay. So just to go through, Virginia right now has 5 of the top 10 highest eviction rates among large US cities. As you can see, number 2 is Richmond, number 3 is Hampton, number 4 is Newport News, number 6 is Norfolk, number 10 is Chesapeake. Then we have Petersburg, Hopewell, and Portsmouth. Your locality may not be listed, but this information still applies to you. Just with this presentation, a lot of people don't understand that it was discovered by Home Housing Opportunities Made Equal and some other organizations, Virginia Legal Aid, that redlining racism is what shaped Richmond's neighborhoods back in the day. If you can see this map from 1937, where Richmond redlining compared to 2016 evictions, you could notice, what was done and why the evictions rates are so high. So again, this is something, again, I'm not going to go through this slide because this was through December 31st, but it's basically the same information I shared at the beginning of the presentation. This is the information, again, of Virginia's new eviction protections for tenants behind on rent starting January 1st, 2021. I won't go through these because this is the same thing I just told you. Only thing I didn't mention is if you do have someone who needs additional information, they can also call 211 and they should be able to connect them or give them the information they need to apply for assistance. But I just do want to point out one more thing with this. The tenant must cooperate with their landlord for this assistance. So they need to cooperate by submitting their check stubs or income information. That's the only thing they need from them. Everything else is done on the landlord's part. So I feel as though if you need help that bad, all you have to do is submit one form of documentation. And the sooner you submit it, the sooner you can get assistance. Just thought I would share. Again, this is the same information I just stated. So as of the old law, ban on source of funds or other discrimination. So basically this is talking about discrimination. So the old law, there were only 8 reasons, and that was race, color, religion, national origin, gender, including sexual harassment, family status, or having children under the age 18, or elderliness or disability. The landlord could deny housing because a tenant wanted to use a housing choice voucher or other source funding. So that means they could deny housing if they had Section 8, or they could deny housing if they were going through us, the Improvement Association. But starting July 1, 2020, the source of funds, gender identity, sexual orientation, and veteran status have been added as 4 more reasons why a person may not be denied housing. Now, not apply to owners of 4, this is key, if they own 4 or fewer rental units, or 10% or less ownership interest in 4 or more rental units, it does not apply to them. I'm going to skip through this one. This is a new law that came into effect July 1st, 2020 as well. The old law stated that landlords did not have to consider a person's status as domestic abuser survivor when reviewing an application to rent. Being a survivor of domestic abuse has after effects that include a lower credit score. So as of July 1, 2020, the landlord must consider the status of domestic abuse survivor when reviewing a credit score in a rental application. The status can be shown by court order, police report, a letter from a sexual or domestic violence program, housing counselor, or attorney. If the landlord violates the law, the survivor can recover actual damages, all amounts paid to the landlord, and attorney fees. So a lot of people weren't aware of this. So if you know someone, and we've ran across a few people who have experienced domestic violence and who are running and trying to get away, and they're survivor, and they have a hard time due to this main issue, due to the lack of credit or rental history. So they cannot be denied if they can show this information. So next is the notice to tenants about legal rights. So the old law in your lease agreement, it did not have to explain your tenant rights. Many tenants did not know basic laws about issues such as evictions, repairs, and security deposits. Sorry, my hand hit that. As of July 1st, 2020, landlords must offer tenants entering into a new or renewed lease a statement of tenant rights posted on the website of the Department of Housing and Community Development. So they have to have this included in their lease agreement. The statement must be signed by both the landlord and the tenant. Landlord may not sue a tenant in any court for any lease violation unless this statement has been signed. And this is important. Again, if they started renting after July 1st, 2020, their rights must be posted within the lease and must be signed. If it is not signed, they cannot sue them for any lease violations, including non-payment of rent, if this statement has not been signed. So this is brand new information that a lot of people have no clue about. So this is very important to know this. Even if you're about to rent something, write a note, sticky pad or something, that your tenant rights must be included in your lease, and it must be signed by you and the landlord. This is just the official letter that came out showing the Virginia Statement of Tenant Rights and Responsibilities as of July 1st, 2020. For application fees, we have ran across some landlords who are attempting to charge a very large amount for application fee. Tenants may be charged a non-refundable application fee of no more than $50. Now, that's not including if you have to pay for a background check or a credit check, okay? And they can be charged at a refundable application deposit. If the tenant does not rent the unit, the application deposit must be returned minus any actual cost or damages, okay? The written lease. Under VRLTA, that's the Virginia Rental Landlord and Tenant Act, a landlord is required to provide a tenant a written lease. If the landlord fails to give you a written lease, the Virginia Rental Landlord and Tenant Act still protects a tenant by establishing a statutory lease between the landlord and tenant for 12 months, subject to automatic renewal. Disclosure, a landlord must reveal certain information to tenants, including, and this is a big one, any visible evidence of mold, the name and address of the property manager, and notice of any sale or foreclosure of the property. Security deposit. A landlord may require a security deposit of up to no more than 2 months of rent. Now, I have some who want first month's rent, security deposit, and last month's rent, but they can get a security deposit of up to 2 months rent. That's it. Within 5 days of move-in, the tenant has the right to object to anything in the move-in report. So key right here, move-in report. A lot of people don't do this. When you're renting a new property, you should do a walkthrough. Take pictures and have a report drawn up with you and your landlord to show, what was actually already damaged or what the property looked like before you moved in one single thing, okay? Also, the tenant has a right to be present at a move-out inspection, which must be made within 72 hours, okay? So a lot of people don't do this. They move out the property, they don't take pictures, they don't do a walkthrough with the landlord, but they want their security deposit back, okay? They want the security deposit back so they can move to another property or help them get another property. But the landlord says, no, you broke my door, you messed up my carpet, you didn't clean my floor. Well, if you didn't do a walkthrough, you didn't do an inspection, you didn't take any pictures, the landlord is going to have the right to keep your money. But per the law, within 45 days of move out, they are supposed to return your security deposit to you so you can use it. If not, you can take them back to court in an attempt to get your security deposit back. Just FYI. So this notice number 5 is subsidized tenants about legal aid. So we don't have a lot of this, but in the old law, public housing authorities or any, like any properties that were Section 8 properties or low income tax credit properties, they had to put on any notice terminated tenancy, the name, address, and phone number of the local legal aid program. And that helped protect some of our most vulnerable tenants. But as of July 1st, 2020, all subsidized landlords must put on any notice terminating a subsidized tenancy, the statewide legal aid phone number and website. Notices are not effective without this information. That's just for anyone, say for instance, receiving any type of rental assistance, most likely at apartment complexes or even a Section 8 voucher or Section 8 property. We don't have a lot of demolishing, so I'm going to skip that one. Okay, this is something new. Okay, I was just talking about the security deposits, okay? The old law, the landlord could charge security deposit up to 2 months of rent, okay? Many tenants did not get their security deposit returned for up to 45 days, making it difficult to pay the next security deposit. Again, what I just stated. As of July 1st, 2020, landlords may allow tenants to provide what's called security deposit insurance for all or part of the security deposit requirement, making it easier for tenants to move from one rental unit to another. okay? The company must meet these requirements or this criteria. Licensed by the State Corporation Commission, payment of premiums allowed on a monthly basis, coverage effective for the entire lease term, coverage no less than what the landlord requires for a security deposit. Insurance company must notify the landlord within 10 days if the policy is canceled or lapses. So this is new. So basically, like you get car insurance, life insurance, any kind of insurance, you now can get security deposit insurance. So if you found a property, it's $800 a month, and they want 2 months of security deposit. You can pay the $800 first month rent, but get this security deposit insurance to cover your other $800 or $1,600 that you need to move in, so you don't have to come out of pocket. Okay, but key, this is for the state of Virginia only. Each state has their own set of rules, okay? But this is something brand new. Oh, this is another one that is common. The old law, some landlords were charging $5 a day after the 10th of the month for late fees if you were late on your rent. So we're always thinking, if I can't pay my rent, how am I going to pay you an extra $5 a day for 20 days on top of the rent as a late fee? I'll never catch up. So, but majority of the time when they went to court with the unlawful detainer, the judges would only grant 10% of the rent. So if it's $800 rent, they can only get $80 per month in late fees. Some courts, depending on the localities, would enforce whatever late fee the landlord said they owed, okay? This non-payment of these extra late fees cause additional hardships as well as cause more evictions. So this took effect April 22nd, 2020. The landlord may charge a late fee of 10% of the period in which they rent. So basically, we have a lot of people who rent weekly. They can only charge 10% of the weekly rent. So if your weekly rent is $200, the late fee can only be $20. But if you're renting for a monthly basis and your rent again is $800, your late fee is $80. It says 10% of the remaining balance due and owe, or whichever is smaller. They may only charge the late fee for a written rental agreement or lease agreement, or under default lease provisions of code. You can look that up later, but basically it needs to be in the lease. And I'm sorry, I'm trying to push through this. I know we're limited on time, but I do want to share some of these key changes that a lot of people are unaware of and they don't know their rights. Now, this is one of the most popular issues that I deal with on a daily basis with renters. So you rent from a slumlord, okay? Or you rent from a landlord who does not repair your property. So me thinking, say for instance, I didn't know the law. I'm not gonna pay my rent until you fix this. But guess what? That's wrong. Well, it was wrong. Because you may have 5 broken windows, no heat, no air conditioner, and you don't pay your rent. They still could take you to court and put you out. That wasn't the proper thing to do. Back before July 1st, it was only one way you can get repairs, and you had to get a landlord a written notice, and you had to list the repairs that were needed, okay? And you had to give them a reasonable amount of time to make the repairs. And if they didn't do that within the reasonable amount of time, we would tell you to take your next month's rent and take it and file it as a tenant's assertion. People like, what in the world is a tenant's assertion? I don't know. What we call it is an escrow account. So what you could do previously is have a copy, send the landlord a letter. I suggested certified with what needed to be repaired. Okay, if they didn't repair it, then take a copy of their letter, go to the court and tell them I want to open an escrow account. So that meant that your rent would be paid directly to the court, and the court would not release those monies into the landlord until the repairs had been proved that they had been made, okay? But starting July 1st, 2020, tenants can give written notice to the landlord of needed repairs and wait only 14 days. This is new, 14 days. If the repairs are not made, the tenant can contract with a licensed contractor, keyword, not your bootleg neighborhood, you know what, trying to get your stuff done. You got to get a licensed, keyword, licensed contractor or pesticide business to get the work done. The cost cannot be more than $1,500 or 1 month's rent, whichever one is higher. The tenant can then deduct the cost of the repairs from the rent by giving the landlord an itemized statement of the work and the receipt from the work. This is new and important, okay? Please, please, please don't say, I'm not paying you no rent because you ain't fixed my door. Don't work that way. You still gonna be outside because you're gonna be evicted. Follow these instructions. Write a letter, itemize it. 14 days, wait 14 whole days. Don't wait 12 or 13 and mess yourself up. 14 whole days. If you can afford it, go get you a legitimate, not your neighborhood contractor, but a legitimate licensed person to get the work done. And the landlord has to deduct the cost of repairs from your rent, okay? This is not available if the tenant caused a condition. So if you got to fight and you and your boyfriend got to fight and got holes in the walls, that's on you. That is not the landlord's responsibility, okay? So you can't say you didn't fix my walls that I put the holes in 14 days and I'm not gonna pay your rent. No, it don't work that way. It cannot be caused by the tenant. You cannot deny access to the premises. So if you want your stuff fixed, you can't say, you ain't coming to my house if I ain't here. So how are they going to fix it? It does not work that way. So this is important. Please, please, please be aware because I see so many people lose their housing because of this. Previously, if you were behind on your rent, you could not do this. It seems though with this new law, you being behind on your rent does not have an effect on it. I have not seen any verbiage on that. So, this is not dealing with the relief to tenants and homeowners due to federal government shutdown. This is not because of COVID-19, okay? This is, when the government shut down and federal employees were furloughed and things of that nature, okay? Under the old law, people were unable to pay their rent or mortgage due to federal government shutdown. They got no special treatment. They're just like anybody else. If you didn't pay your rent, you gotta go. I'm over my time. I'm gonna try to speed this up. I'm almost done. But effective April 22nd, 2020, federal government shutdown for more than 14 days triggers protection for federal employees, contractors for federal government, employees of contractors for federal government, okay? So there are some special protections in there. I won't read all of those. We already talked about the COVID-19. So this is another big one. ExParte orders of tenant is unlawfully excluded. Old law, if the landlord locked you out, self-help eviction, cut your water off, the tenant could file a petition or relief for unlawful exclusion. They had to get an order to recover possession, resume utility or damages, so forth. They had to go back through the court. As of July 1st, the tenant can get a temporary relief even if the landlord has not been served, okay? So they still have to file the paperwork, but they can get temporary relief to get back into their premises temporarily, even if the landlord has not been served the paperwork yet. The tenant must have a good faith effort to notify the landlord about the petition and the hearing. So I just want to share that. We're gonna skip through that one. Oops. So basically, this is about mobile homes. I think I hit most of the key points, but I did want to share this particular slide. If you are facing any of these issues with renting, this is who you can contact. You can contact, you know, the civil legal aid, eviction legal line. There has some pro bono question websites, legal information. So this is the information to try to help yourself if you find yourself in one of these situations. I'm sorry, I went over my time. I tried to speed through, but give as much information as possible. I'm not sure if anyone has any questions, but they are welcome if you do.
We want to say thank you so much, Erica. This information was really, really great. And I don't know about anybody else, but I do have a page worth of notes. And then there are a lot of people requesting to have the slides as well. So I'll make sure I get with Erica and we can see if we can share some of that information that she showed today. And as we said, this was recorded as well, so we'll have that accessible. But yeah, if you guys have questions, please take time to ask questions. You can do it in the chat box. You know, we are over time. We want to be sensitive to it, but, you know, also we want to make sure that we're being helpful. So if people have questions, please don't be shy. Go for it. Okay. But if not, then we're going to, if you can just turn on your cameras if you're there, and let's just do a virtual round of applause for Erica. This is not easy, y'all. It's not easy to talk and share that information, and it almost feels like you're alone sometimes, but we want to say thank you. You did a really great job. We're so fortunate to have you on staff and a part of the organization. So without further ado, we will catch you all back for the next Thoughtful Thursday. We're trying to put some tax information and a tax presentation together for next week. Which was not originally on the calendar, but if you guys are free, definitely join us for that. And without much to do, thank you guys. And Erica, as we can see in the chat box, people are saying great information, very helpful.
Thank you guys, I appreciate it. I'm sorry I had to kind of fly through so fast, but it's a lot of information to try to share in 30 minutes.
It is my fault.
No, it's okay. I tried to give you a condensed version.
It was great. It was really great. You did a great job. And hopefully this information will help somebody in need. So thank you guys again for being here with Thoughtful Thursday with Head Start. And we will catch you guys next week. Have a blessed afternoon. Bye.